I can start with an introduction. Hi, I'm Matt Chapman. I've been working with FOIA for about 7 years now, working with Lucy Parsons Labs, Invisible Institute, Chicago Reporter, the Tribe, and various things on mostly with parking tickets and a little bit of police transparency here and there.
I can go next. My name's Nona. I'm a health insurance reporter at Modern Healthcare Magazine, and my work has appeared in the Washington Post, Vice, Smithsonian Magazine, and elsewhere.
I'll go next. Freddie Martinez. I'm the executive director of Lucy Parsons Labs. We've been doing FOIA and transparency around policing work in Chicago for about 6 years. And on our very first FOIA lawsuit, we were represented by Matt. So it's great to be here and have so many, full circle.
Hey everybody, I'm Matt Topic. I run the FOIA practice at Lovie & Lovie that I started about 7 years ago as a second stage in my career as an attorney, and I've done literally hundreds of Freedom of Information Act cases in Illinois against the federal government and in other places around the country. So I think we were going to have Matt start first. Talk a little bit about his experiences, and then we'll just sort of take turns talking about what we've learned about FOIA, have a little bit of a discussion, and leave plenty of time for questions.
Cool, thanks, Matt. So my experience with FOIA, specifically around litigation, I first submitted my first FOIA request about 7 years ago. And maybe 2 or 3 FOIA requests after that, I submitted a FOIA request to City of Chicago's Department of Information and Technology, where I was looking for the phone records of the mayor's office of Chicago. They provided back basically a nonsense redacted spreadsheet that had private information included and government information excluded from it. So I had to go down the process of going through the appeals process within Illinois to get the request appealed through the Attorney General, which took a good 8 months. And after that, the AG's office was basically ignored by the City of Chicago. After the appeal was done, which side had been my side, to which I had to then file litigation with Lovie & Lovie, Matt Topic as my representation. Besides that, I've also done a lawsuit against the White House Office of Management and Budget, where I was looking for email metadata of the White House OMB for January 2017. And currently I have 2 lawsuits going on, both of them with Lovie & Lovie, Matt Topic and Merrick. Both of those are for database schema information. So like the column information and then the table names of records inside of a database, which they're currently exempting for security reasons. So I'm currently going down the process of trying to argue through litigation with the help of Matt Topic and Merrick at Lovie & Lovie, to essentially argue that the release of table names and column names would not compromise security, which is an absurd idea. My experience with litigation is by no means an expert in litigation, but I think that the experience that I've had with litigation in FOIA is that it sucks, but it's needed. It's one of those things where like the specific pieces of the law that we're trying to work with aren't necessarily fleshed out. So what we need to do is we need to like argue against these sorts of issues. The issue that I'm working with right now is a specific exemption of network security, where they're saying that if they were to release the schema, it would compromise their network security. So now we have to go down the process of going through court and going through trial as well to argue that. So what we had to do with that was we had to hire an expert in cybersecurity who represented us in the trial, and basically argue against the city of Chicago's chief information security officer that it would not compromise security. It is it's an experience, but I'm basically just trying to go through like the very basic things right now. So feel free to like step in and ask me questions if you have any. But the specific issue that we're working on is one that's been around since 1987. The language in the law has been in there since 1987, and kind of my experience with this is that the records that I'm requesting as part of these lawsuits are what I consider to be pretty fundamental to being able to get information out of U.S. governments. Basically, what the information allows me to do is to figure out what information exists, which then lets me submit future requests. They do not want that to happen. Between City of Chicago Police Department and City of Chicago's Department of Finance, they are pushing as hard as they can against the release of information that would allow requesters, and for what it's worth, I'm doing this as an individual. And in these situations, where like an individual has to basically like fight to the tooth against these massive government agencies, it's completely ridiculous. It is a situation that I feel like we've been in for a long time, and I think that one of the only ways that we can the only way that we can continue forward is either through litigation, or improving the law, or just fighting. So like what I like to do with this sort of litigation is just push as hard as I can on like these sort of fundamental issues that just haven't been resolved, whether it's through reporting or whether it's through activism and whatnot. There are just all of these outstanding issues that just are out there, and they need to be worked on.
Hey Matt, let me ask you a question. So people watching this who've done any amount of FOIA litigation would probably be surprised to learn that we actually had a trial, because typically these kinds of cases get resolved just in motion practice based on affidavit. So could you maybe just give a quick overview of kind of what happened at the trial, who testified, what was going on, and what the outcome was?
So the trial was earlier last year, about a year ago. The specific request was for the database schemas with column names and then the table names of the City of Chicago's Department of Finance's parking tickets database. So again, the reason for requesting that is to figure out what information exists and then submit future requests. They were exempting it for security reasons, and it eventually led to a point where we had to go through trial. Which we did. And so what happened was I had an expert witness who is Tom Tachek, who has been the owner of several security companies. He's been working in the industry for about 25 years. He acted as my expert witness and basically testified that no, the release of a database schema would not compromise network security. And then Chicago's chief information security officer testified on behalf of City of Chicago, giving what I think is one of the worst explanations of like how security could be compromised, citing things like 0 days, internal employees having access to information that would allow them to compromise network security. There was a point in the trial where the City of Chicago's counsel at the end, I believe it was in their closing statement, said that the only reason that I wanted the records, the database schema records, was so that I could compromise their network security and modify records inside of the City of Chicago's database. That is something else. It was a time where City of Chicago literally weaponized let me take a step back. So they said that because I call myself a civic hacker, that was enough to say that I was interested in modifying their data, which couldn't be anywhere closer to the truth. So they weaponized in court to a judge that the only reason I want these records is to hack them. So like in litigation, we have these kind of like major issues where we have these fundamental ways to get information that aren't accessible, digital information, so information behind a database, that judges don't know, aren't technical enough to understand like the nuances of like why we need to do this. And City of Chicago's lawyers very intentionally weaponized that fact to make an argument that was completely false. So litigation is fun. So yeah.
So I think you sort of buried the lead just a little bit. Do you want to tell everybody what the outcome of the trial was?
Yeah, sorry. Thank you. The outcome of that trial was that the judge did side with us. He said that my expert witness gave a compelling argument that security would not be compromised, and that City of Chicago's CISO did not give a compelling argument, and they ordered the release of those records. City of Chicago is now appealing in that on the grounds of a legal argument where they're effectively saying that the use of the word would in would compromise is enough to put question into the law of like whether or not the exemption that they use applies. So that was a year ago. We're currently still in appeals. And that's for the City of Chicago's Department of Finance. I have another lawsuit against the City of Chicago Police Department where they're using the exact same exemption for the same reason, despite the fact that we have a judge on record saying that that the security exemption is not exactly convincing. So we have these massive legal, it's like rabbit holes that we need to get out of before we can start doing like fundamental like data work with FOIA. Yeah, it's absolutely insane that we have to go down this route. As far as I'm concerned, like I said, this specific component of the law was built in 1987. That was a long time ago. That was before I was born. But we still have these fundamental issues that just they're still there. And as far as I've seen, as far as I can tell, like no media organization is working on these fundamental like digital issues within Chicago. There are some who do some things, but on these like deep fundamental issues, I haven't seen that much. And I'm of the opinion that a lot more aggressive litigation needs to be done so that we can get out of this hole that we're currently in, so that we can, one, know what's happening in the City of Chicago with our police, we can know what's happening with like our ticketing system, and we can just generally know what's happening in Chicago. But every step that we take, City of Chicago pushes back, and it's sad that we have to do this. Cool.
And especially on anything technical, right? It's like technical issue. There. If I ask for emails, or phone records or anything that's stored electronically, there's just no chance. Well, not no chance. But yeah, I've had the same experience. So I'm glad you talked about that, Matt.
Yeah, and I'll just add, I mean, I think the reason we were able to get to where we got to in that case was because we had a very good expert, and they are out there, and, work your Rolodex. I mean, and those people that who can speak to these kinds of issues, who hear an argument like, oh, the database schema will will allow a hacker to hack the system and like, laugh and laugh and laugh at how ridiculous that is. You'd be surprised how often those people are willing to get involved, often at no charge in a lawsuit because they're so annoyed and angered by it. So that was how we got to that point. And also, I mean, in federal court, it would have been harder because federal FOIA is a lot more generous to agencies than Illinois FOIA is to Illinois public bodies. So, there have been cases that accepted this same kind of argument under federal FOIA, but there's a lot of differences between the statutes, which is kind of a good thing to remember. So, Nona, should we hand it over to you to talk about success in even avoiding litigation?
Sure thing. Very impressive, for lack of a better term, Matt. But yeah, I'll take it back for a second to when I was a reporter at a local newspaper. There was some controversy with the local Board of Education. One of the members resigned unexpectedly, and she was a pretty controversial figure. Both her and her husband served on the board, and she wasn't liked in the community. But regardless of who she was, I just FOIA'd for her resignation letter because I think that's best practice. And within 5 minutes, the superintendent was like, "No, you're mean, like you're the worst." And he rejected my FOIA. I was not being mean, I was doing my job. And I decided to appeal the case to the Illinois Attorney General because it's public body, she's an elected official, it's public information. So I just want to show you guys how easy it is to appeal cases to the Illinois Attorney General. So I'm going to share my screen. All right. Awesome. So first, go to the Illinois Attorney General site. I think I just Googled like FOIA Illinois Attorney General. Go down, you'll see all of this. Public access counselor, keep going, keep going. Requests for review, that is what you want. So press on that link and you will get a 1-page, super easy outline for how to appeal a rejected FOIA. Because it was my first time appealing any rejected FOIA, and because it was so egregious, I was like, I think I've got a pretty good case here. But it was my first time. I didn't know how to do it. So I just Googled to see if a form existed for how to format my appeal request. And lo and behold, there is something on the Attorney General's site that shows you how to do that. So I clicked there and I filled out this form. I think it took me maybe 5 minutes. And I submitted it to the Illinois Attorney General. Let me stop sharing my screen. Let me see if I can figure that out. Well, regardless, I submitted it to the Illinois Attorney General, and within a week, I got a call from the public access counselor saying that I was right. I had access to the letter of resignation and I got it. And it was probably 3 sentences being like, it's tax season, I'm a CPA, I'm busy, I gotta resign. There wasn't a story there, but I'm glad I did it. And I think it helped kind of clarify for the superintendent, I am a reporter, this is a local newspaper, and my request was perfectly within my rights. For submitting this, it was important that I also had a copy of all of the information, like all of the email correspondence between me and the school superintendent. So the original FOIA request, as well as his rejection and his subsequent complaint to my boss calling me mean. I forwarded all of that to the Illinois Attorney General, and yeah, within a week, I got that letter. So I encourage everybody to do that. It's really easy, and I hope this helped.
That's interesting because one complaint that a lot of people have had is that your experience of getting it resolved in a week is you have a magic touch there or something. Because one frustration I know sometimes people has is it may take 6 months or longer for the Attorney General to rule. Now sometimes within a week they're always going to say, yes, we're going to review it, or no, we're not going to review it. And if they almost always review it unless it's like you're totally obviously wrong. Or if the public body is so obviously wrong, they may just immediately like rule on. Like if they just said it's denied because you're mean and they don't assert any exemptions, then you might get a ruling quickly. Sometimes though, it can take a while, and sometimes public bodies don't follow those rulings even when they, you might win and then they say, well, it's not a binding opinion, and so I'm not going to follow it. Could you talk a little bit about sort of, I think especially people who cover maybe smaller communities where the public officials can be a little bit more sensitive to FOIA requests or anything adversarial. How did you work through that? Did that cause any issues or frustrations for you in terms of just kind of continuing to cover them in the future?
Good question. Yeah, it really actually destroyed my relationship with the local school for at least 6 months. And it was very awkward because for anyone who's been a local reporter, you go to these meetings and it's all of the board members sitting in a circle. And oftentimes I was the only one in the audience, just like staring back at them awkwardly. So as a way to repair the relationship, I just tried to be like really conscientious and consistent with how I covered them. I went to every board meeting. I made sure they knew that I was recording all the meetings because that was not something that was being done. And I reported on everything. So I reported on how they were spending money, interesting initiatives with the district, cute kid, like fun feature stories. And after about 6 months, luckily their PR person ended up taking a different job. And I took that opportunity to buy the new PR person coffee, introduce myself, and really talk about like how I was hoping to cover the district going forward. I also tried to ask all of the other board members for coffee, and luckily one of them said yes. And that really helped repair the relationship. I don't regret appealing the decision to deny my FOIA because, again, it was totally egregious that he did that, and it was honestly insulting. But just be prepared when you are covering a local, like smaller entity. People take things really seriously. So just be prepared to stand up for yourself and be confident in your decision.
Very good. Freddie?
Yeah, thanks, Matt. Also, just a little bit on Nona's PAC thing. Especially with larger agencies, they know all the loopholes and they will exploit them. So, for example, City of Chicago, Mayor's office, they know if they don't turn over the records to the PAC within 60 days, that you can't force you can't force a binding opinion on them. So they do this all the time. Is why we litigators all the time, and we just have to sue because agencies do know the loopholes, especially the larger ones. But it also does help for us to know the law. So at least in Illinois, a government can't claim that a request is unduly burdensome if they don't respond within 10 business days. CPD always misses their deadline, always claims unduly burdensome. We always say you improperly are applying, G, always litigate that. So it does help to know the PAC, it helps to know the law. But I just wanted to highlight a few specific cases that we've brought. The first one, and this one is one that I think it's funny, but it's really not funny. And this was a national security case that we're currently litigating. When the leader of ISIS, al-Baghdadi, was killed in a raid, there was this controversy where the dog Conan was brought to the White House, and Trump was saying he's a really good boy. He was injured in service. He nearly died. Conan eventually, after like 2 or 3 weeks, says that it's a guy, it's a he. And out of curiosity, we FOIA'd for that. And I actually wrote an article about our experiences that I posted in our chat. And the government claimed it a national security secret, and they went to so far as to say that they could neither. Well, they glomarred it, right? So they said, like, we can't even tell you if records do it. Security secret. Have like literally Trump at the White House, on the White House lawn, saying, he was injured. Clearly there's some veterinary records there. It's just completely implausible. And it really, like, we litigated that case. We are litigating that case. Just on the absurdity of how far the government will go to classify things, in violation of even classification orders. Like, you can't classify something because it'll embarrass the president. But we do, and it really upsets me. I wrote this sort of tongue-in-cheek article about it, but the fact that governments do this, and the only real avenue you have is litigation, and even that one with the Glomar case, it's very, very much uphill battles. Really shows you the depth to which some governments will go to deny your request, and to make it as difficult for you to get your records. So that's one case that we were litigating that I thought was really important. We also litigated a case in Chicago with the University of Chicago's crime lab. So, some states have a requirement that contractors that do governmental operations are subject to FOIA, or the government, those contractors' records are treated like agency records, right? So the work that the crime lab is doing with the city of Chicago, they should be treated like CPD records. They did a joint presentation with law enforcement officials at one of these big law enforcement conferences. I asked for the records that CPD had, and I asked for them to go and get the crime lab's records. They claimed that, well, no, crime lab's not such. And here it's important to set a bit of context. The crime lab literally has analysts that they take from the university and sit them side by side next to CPD analysts, like in the police station or similar stations, and work with them. It's on their website. They're quite proud of it. They raise a lot of money to do it. And so for them to claim that was like not a governmental operation, I mean, the judge was like, I don't know why you would claim that that's not a governmental operation. What's more fundamental to government? And the judge sort of heard enough of the city's arguments and ruled from the bench that those records were subject to FOIA and that the crime lab had to turn them over to us, or that the city had to get them from the crime lab and turn them over to us. And the city is appealing that decision right now. And again, this is one of those places where I think we should, if we have the tools to litigate, we absolutely need to. There are estimates that like a third of the federal government work is done by contractors. And so you have this invasive creep of privatization of core governmental functions that's just hidden in secrecy. And so, I think it's important for us to be thinking about where that overlap is, bringing cases, shining light on those situations, because you can't sort of, post at the University of Chicago, that's absurd. And then finally, there's another case that I wanted to highlight, and this was a case that relates to HHS at the very beginning of the pandemic. We know that the White House was giving them orders to stifle scientists, to tell scientists that they can't speak to the media. And that has obviously very serious health risks with it. It's, and I'm going to sound like I'm exaggerating a little bit, and it is, life and deaths. It can be, right? Like the ability for governments to hide things. FOIA, at my day job, I'm at a nonprofit called Open the Government. We brought a lawsuit with another group called Government Accountability Project. And we were able to show that the HHS is stifling scientists, and brought a complaint to the federal government and asked them in the new administration to rescind those policies, which we've been told has happened. So, we couldn't have had that happen without litigation. And it's a shame that we have to resort to litigation, 3 or 4 or 6 months into a pandemic, that we're really beginning to government body the response. And we shouldn't have to litigate that. That's the exact opposite of what we expect our government to exist for. And so I just wanted to highlight those 3 stories. I mean, I think they give you different perspectives of how far the government goes and why we have to hit every nail with the hammer of litigation, but it's there and we use it.
So Freddie, anyone who makes federal FOIA requests with any degree of frequency has probably gotten accustomed to extremely long wait times. I think for the FBI right now, if your request calls for more than 50 pages, it'll be more than a year until they even conduct the search for records. Sometimes the wait can be even longer. COVID has made that even worse. Can you just talk a little bit about how litigation affects that? If you've got a really long estimated completion date, have you had success bringing lawsuits to get records produced more quickly?
Yeah. So, I think with the federal government, it's been, I came from, dealing with Chicago, where it's long, but it's even faster than the federal government, but by no means within the 10 business days, right? On the federal level, it's much longer periods. You obviously, people talk about keeping good track of your requests. Well, now you have to, remember things that you did 6 months ago. The administrative appeals are really important, right? So you have to appeal immediately. You'll find situations where things like they'll remand searches and just never do them. So litigation is really like the only option in those circumstances. And even when you get a favorable decision by a judge, agencies will say, we can only produce 500 pages a month. They'll look that they already released and give those to you as if somehow they're relevant. They'll send you news clippings. I mean, we're litigating against the FBI right now for its records on John Burge, and it's giving us records that have been public for 20 years. So it's very challenging in that you really do that research, that narrowing of your request as much as you can does sort of help a lot, but it's just frustrations all the way. So you just have to be aware that if even a favorable decision, you're going to get a bunch of documents that don't have anything to do with what you requested, but because it's expedient for the agency to say that they're producing something. That doesn't mean you get 500 pages a month. They review 500 pages and they'll redact out whatever they want and give you, 10, 15 pages, sometimes 0 pages. And so, on the federal front, it looks like that. Basically, across all the DOJ components and across the bigger agencies like State Department. The federal FOIA system is bad in need of repair.
Great. So I'm going to just talk a little bit about kind of what FOIA litigation looks like for those who haven't done it or haven't done a lot of it, and then we'll leave a lot of time for questions at the end. So I'm going to talk about both Illinois FOIA and federal FOIA. I know we have some people here from all around the country. Every state has a different statute. There's similarities, there's differences. So I'll talk about Illinois and I'll talk about federal, but some of these principles, are probably going to apply in just about any state, although there can be a lot of differences. So let's talk about Illinois first. So if your request has been denied, which can either mean they don't respond by the deadline, or it can mean they've expressly denied the request, or it can mean that they say there's no records and you think there are, or they produce records and you think there's more. Those are all things that you potentially can challenge as a denial. And the statute says that you can go to court to challenge those. In Illinois, you no longer have to exhaust any kind of administrative appeal within the agency like you have to do often for federal agencies. As soon as there's a denial, which includes as soon as a deadline passes without a request being answered, you can go to court and you can challenge that. You have the option of going the route of the Attorney General's office. that Nona talked about, but understand that's not a prerequisite. You don't have to do that first. And if you can start that process, and you can always bail on it and file a lawsuit, and then the Attorney General's office will close the request for review and you go down the lawsuit path. So if you decide to sue, the government has to prove by clear and convincing evidence, which is a heightened standard that's just a little bit below the standard of convicting someone for a crime. The government has to prove that it did a reasonable search for records, which means they have to explain how they did the search and show that that was a reasonable approach. They have to account for every document they withheld, often in the form of an index, which would include at least kind of to, from, and date type of information, which in and of itself can be useful sometimes, even if you don't get documents. And then they have to prove by clear and convincing evidence that an exemption applies, and the exemptions are supposed to be narrowly interpreted in favor of disclosure. So the scales are very, very heavily weighted in favor of you as the requester and against the government. The biggest challenge you have is that the government can meet its burden of proof by providing affidavits instead of going through a normal discovery process with depositions and stuff like that. And there's a lot of law that says government affidavits are assumed to be true and given a presumption of good faith unless you have some concrete evidence to poke holes in it, which can mean, as I talked about earlier with Matt's cases, you have your own person to furnish affidavits to contradict it. But that said, especially if you're talking about, we'll pick on the Chicago Police Department because they're a frequent FOIA violator. They consistently fail to provide affidavits to meet their burden of proof. So I did the Laquan McDonald case. It was really one of the first cases to succeed on the argument that just because there allegedly is an ongoing investigation doesn't mean that's enough for the government to be able to withhold the records. They have to prove that not only it could interfere with an investigation, but that it would interfere with an investigation. And so, that has always been in the law, but that hadn't really been challenged. And a lot of journalists, I think, got used to the idea that as long as they can say the investigation is open, they can withhold everything. And that is not actually what the law is. So we won that in Laquan, and we've had to fight that in case after case since then. And almost universally, courts have found that CPD's efforts to prove that it would interfere with an investigation to release videos have failed, meaning that the records end up being produced once you file a lawsuit. An argument we often make is, look, Judge, they came out in the press the day after this officer-involved shooting, and they said the person had a gun, and he was pointing the gun at the officers, and they already justified the shooting in the press. So if they're really worried about interfering with witnesses and things like that they say release of the video would cause, then why are they out there telling their story? Because don't you think it would intimidate a witness to know that this is the official CPD line of what happened? And if I saw something different, I have to go be adverse to the Chicago Police Department. So of course, what they're often doing is just trying to control the narrative, which we've seen over and over, including in Laquan and since then. So my point of all that is that that very often agencies at the state and local level are just totally unable to meet their burden of proof. And so when you add all these things together, you go into litigation with this massive advantage over the government. And so we don't win all the time, but we win more often than we don't. The other thing you should know is that the statute provides for the recovery of attorney's fees. And in Illinois, the court must award your fees if you prevail. And the different judicial appellate circuits are somewhat split on whether you have to get court-ordered relief versus you sue and then they change their mind and turn over records. And in Cook County, that second thing will still entitle you to fees. If you're out in Lake and DuPage in the second district, they've said, no, you have to have a court order. So at least in Cook County, it makes it very easy for our firm to represent journalists, either very often at no cost or at very, very reduced costs, or just, a few $1,000s flat fee, and that's it. You don't have to pay anything else. We're very flexible. Very often, we just do it for free because the statute allows you to recover your fees if you prevail. Federal FOIA, a lot of similarities. It's a little harder to recover fees, but you often can, which changes just the calculus just a little bit, and when we can take cases on that basis. The burden of proof is not as stringent. There's more of a presumption in favor of the government. It can be harder to win federal FOIA cases, but we have won plenty. I mean, we forced removal of some of the redactions to the Mueller report on behalf of BuzzFeed. We filed tons of cases just trying to get productions moving, so that you can move out of this, being State Department. I mean, you might wait a year for the State Department to even tell you when they're going to respond to their request. You get into litigation and it tends to move more quickly than that. So, I'm a proponent, as everyone could imagine, of, if you get a denial, you should challenge it. And the litigation isn't like you're not going to have to sit for a deposition. I don't think I've ever had a client in a FOIA case have to even respond to any kind of discovery. It's pretty hands off. I mean, from your perspective, we do the litigating. I mean, you'll need to review things, give input. Sometimes, like in Matt's case, we'll ask you to work your Rolodex and help us find an expert who can provide a counter affidavit. But you can come to court if you want to, but it is not something that really has to be a huge distraction or taking time out of your day. And when it does, like, in Matt's case that went to trial, Matt, I would imagine you probably found that to be like a pretty darn interesting experience to
It was
have,
incredibly interesting.
to go through that, right? So that's sort of the lay of the land of FOIA litigation. I think there's some people that have very good luck with the kind of catch more flies with honey than vinegar approach, and if you're one of those people, that's great. But sometimes it doesn't work, and sometimes it does require a hammer to really force the release of stuff. And I think last year we started keeping count. I think the count was somewhere between 90 and 100,000 pages of government records that got released as a result of our lawsuits. And I think it actually was probably more than that. And then, videos and audio and all that kind of stuff on top of that. So with that, I think we'd like to open it up now to questions, see what questions people. So Tasha, I think you are the keeper of the questions, yes?
Yep, just the one question so far. Everyone's just really listening and enjoying the conversation.
Okay.
So the one question we have so far is on that giving you useless already public documents issue. Do any of you have any suggestions for avoiding that step and making it clear that those records are not acceptable?
Yeah. On the federal level, it's a lot more challenging. Because usually the judges will not really listen. Usually what will happen is they'll set a production schedule. When you're done with production, they'll say, how are the redactions? Are they adequate? Do you want to challenge them? And if you're happy, we'll dismiss the case and usually award your attorney fees. And that can take years. So sure. Usually what happens, at least with the team at Lovi, is we'll have a kickoff call of some kind, and we'll say, like, what are you really interested in? So we sued for the FBI's records on Whitey Bulger. I'm particularly interested in whether or not he was actually an FBI informant. Lots of great movies made about that character. But I think that would add some kind of historical perspective, and I'm not really interested in all the other stuff from the 70s and 80s on him. I really do want to know that question, right? And so usually, didn't confirm what we're looking for and why we filed the FOIA, and that's usually like the start of the meeting and conferring with opposing counsel, and usually like, you can sort of make an overture about like what it is that you're actually looking for, and not too dissimilar, like when you're actually making a request and talking to the FOIA office. And I'm really interested in this set of data, whatever it is. So you can also do that in court as well.
Yeah, I think one thing I would want to add on that is like, if they do give you documents that have already been made public, you can always submit a new request, and explicitly say like, don't give me this document, like literally say, don't give me this document, or say that you're aware that the document exists, or you're aware that a source of documents exists. And then you basically are compelling them to do a further search. So you're reestablishing what reasonable search means in that sort of scenario.
Yeah, and that reasonable search thing is actually, I think, gives people a lot more leeway than we think. So, you know, even when you appeal to the PAC, they do their, like, we don't have a right to discovery, but there's a kind of pseudo discovery you can do where the PAC will tell you, we asked how they did a search and they told us we did this and that and that. And that might be another way for you to learn, like, oh, they actually didn't search. They just asked one person if they had records. And the PAC will oftentimes, you know, tell that to you or will work with you, or, you know, and that might be a way for you to realize that, like, that's not a reasonable search. And so it helps.
Nona, have you had issues like that in your dealings with, you know, school boards and kind of smaller local entities where they kind of they give you stuff that isn't exactly the stuff you were looking for?
You know, I've gotten pretty lucky, so I can't say I've had that issue, but I will go a little bit against what Freddie mentioned. I knew that an elected official in the town I covered had gotten a DUI, but I wasn't sure what day and I wasn't sure where. So I just asked the state police, I FOIA'd them and I was like, I would like all records for this guy or any reports that you have. And then the public information officer was like, well, do you want like the police reports or do you want this? And I feel like I'm not explaining this super well, but it turned out he actually had been arrested for 3 DUIs, 2 within one day and then the next day. So sometimes it pays to be a little bit vague and just say, I'm looking for all the records you got. And I've found that public information officers really want to help you.
That's a great point. And I think some of that phenomenon is a difference between federal government and local government, or in somebody like the city of Chicago mayor's office is maybe getting closer to the federal government side. For I don't know why, but federal agencies seem to spend a lot of time emailing press clippings. Like, they love press clippings. There's daily press clipping emails. And so, like, there's just a ton of press clippings. And that is a thing that, you know, for a lot of our clients, we already know off the bat, like, hey, you guys can exclude press clippings unless they're forwarded with some additional commentary. Forget the press clippings. We don't need the press clippings. And so, you know, those are the kind of things you can kind of sort out either up front or in the middle of litigation when they're in the middle of producing records. You can make some adjustments. So we have go ahead.
Can I just add one comment?
Yeah.
So one thing I've seen, like with the City of Chicago mayor's office, is if you just call them, they are happy to work with you if you are a reasonable person with them as well. Police department, not so much. Mayor's office is a little bit more, I think, receptible to just like having a conversation. Recently, I worked with the mayor's office's FOIA officer to try to get email metadata for all of Crime Lab for 13 years worth of metadata. They initially rejected the request, saying it would cost about 50 hours worth of work. So I made a spreadsheet for him that just automatically redacts the records, simplifies the records to about 1/10 of the size. And he was able to do it without the unduly burdensome rejection. So like, there are things that you can do. Another point I'll make really quick is that, like, if somebody tells you like a link to an external source that has information that you're looking for, a lot of the times that's not necessarily complete. This is the case, I think, with like contracts online. So like, if you have a web portal that has like a bunch of contracts online, it's probably not a complete set. And if you tell the FOIA officer that, sometimes they probably just won't respond. So you kind of have to take it to the next level when they don't respond, so that you get those kind of like hidden records that would require a like more comprehensive search.
Great. So we had a question about what types of records are more successful in obtaining in litigation versus others? How do you strategize about the harder to obtain record? Generalize that question just a little bit, give you my thoughts, and then see what others have to say. I think one area where there's a lot of challenges is anything school related that is student level information, even with names redacted. That is just a mess to deal with, because what the schools often say, and they're, depending on the circumstances, there may be some validity to this, is like, look, even if we redact the names, if we give you enough data points, someone in the community, even though you can't tell who that person is, someone in the community might be able to do that. I mean, an easy example would be if there's racial demographic information and they tell you the classroom in the year, and there's only one person who falls into that demographic category, then you won't know who that person is, but someone in the community will know. And then you add on top of that, the courts are extremely protective of student privacy kind of issues. And you just say FERPA, which is the federal statute on this, and there's like a state statute too. Those can be very challenging, and it gets compounded with the burden, because if there's a lot of records, even if it's only going to be a few instances where that might occur, the school district can argue, well, I still have to go through all of them to figure out which one those are. And that's where the burden comes into play. Everyone should know, I'm not saying everyone already knew, but I want everyone to know that under the law, if they don't respond by the deadline, they're not allowed to claim that it's unduly burdensome. So I wanted to make that point, because that can be incredibly powerful. There's a case that just was argued in the Illinois Appellate Court on some peripheral issues, but the core issue was it was a request for every single complaint of misconduct against any Chicago Police Department officer ever, and all the investigative records from all those complaints. And CP, as it often does, failed to respond to the request by the deadline, and the trial court held them to the waiver and said, I don't care that it's going to cost millions of dollars to produce these records. This is what the law says. So anyway, I think school student records are a challenge. Sometimes we run into tough times on security videos. There's an argument like, well, if we release the videos, then perpetrators or terrorists would know where the cameras are located, and then they could better attack things. That kind of can go a little bit like either. I've seen that go either way, but I think judges, the greater the magnitude of potential harm, the more likely there's going to be deference. I mean, we lost a case a while ago on the swipe in and swipe out records at the water district, because the city was like, well, water plant, it's a high, it's a high value target to terrorists. And if they knew who was coming in and out when, they could better plan an attack, which I think was pretty thin kind of an argument. But I can understand why there's, even though the statute says presumption of disclosure, there's some instances where there's like threat of terrorism where the scales ramp way down, and understandably judges, I think, are more reluctant to allow that stuff to be released.
That's definitely my experience with asking for. I do a lot of work on surveillance technologies, right, and really mapping out how these things interact, and really trying to get the public to know, here's or whatever it is to litigate a lot. They just throw the word terrorism in there, and it's hard to justify. It's harder to challenge that. But what does help is, people act like, police departments and the city or whoever, their council will act like these things are super esoteric technologies. But you see it in like Hollywood, Brooklyn Nine-Nine has an episode about this, license plate reader technology. And for people to claim that it's somehow a specialized investigative tool is just, laughable on its face. But it does raise a lot of challenges, especially with like anything about like electronic surveillance or anything that's kind of technical, that does that does bring a lot of challenges. And that's, I think, Matt Chapman and I's experience for the most part.
Nona, how about you? Things that you things you've noticed, like, you know, you've had a tougher time getting released?
Yeah, I had one case and it was really weird. I FOIA'd the Illinois Board of Elections asking if anyone had FOIA'd for records on one of their employees. I had a feeling someone was kind of creeping on her emails. And I was right. I got his FOIAs and I found that out. And I wanted to see if someone was, so then I FOIA'd the University of Illinois at Chicago, a public university, about one of their employees to see if anyone had FOIA'd for their information. And I wasn't able to get it. And he kept, like, the FOIA officer kept being like, I get like hundreds of FOIA requests a day. I don't know what you want. And I'm like, I really just want to know if anyone's FOIA'd this guy in the past 3 months. He's only one employee. And yeah, unfortunately, my request was denied. So I've had some trouble getting copies of other people's FOIAs.
Interesting.
That's
The
really
one
interesting.
that we have to litigate all the time, and that's the emails, documents requests, right? So every time we ask for documents, they interpret it as emails, and they say you'll have to give us the person's email address, and then who they're emailing, and the keywords, and the dates and times. And it's like, I don't have a directory. I don't know who they're emailing. That's like the whole point of the FOIA. And you ask for documents, and they interpret that as emails when you don't say emails, or you say emails and documents. And so we litigate that one all the time, because it's one of those escape valves that agencies always try to use. And I've lost count of how many times I've gotten that response.
Yeah.
So we had, I think we're just about out of time. We had, let's maybe just one last question, which was about records from deaths of inmates in county, state, federal correction institutions. That's like a very specific question. Let me just say, generally, anything that's in an inmate master file for at least state institutions is just completely exempt, and a lot of things get kept in a master file. I feel like there is some other record that has to be created when there's been a death in custody, though.
I can talk a little bit about that.
Yeah, great.
So the like county morgue, or I'm blanking on the name of the actual department, they do keep records of deaths. And when somebody dies in Illinois, at the very least, when somebody dies, privacy does not apply to them anymore. That's not necessarily the case with like COVID data, for example. So like if you try to request deaths from of someone who died of COVID from like the Department of Public Health, they will reject it because of HIPAA reasons. That said, you can get those records from agencies that aren't under HIPAA, the county morgue, for example, and they will give you death records, and they will give you death records of like of people who died in Cook County as well.
Very good. Well, I'm told we have exhausted our time, so glad everyone could join us. I think it was a great discussion, and hope everyone enjoys the rest of FOIA Fest. If anyone ever has, none of us, I don't think, are very hard to find. I'm sure I speak for everyone that we're more than happy to talk FOIA at any time. So keep the conversation going.
Awesome.
Thanks for your time, everyone.
Take care.